Utah versus Kouri Richins. She has been accused of the attempted murder and then subsequent murder of her husband, Eric Richins. There are also numerous fraud claims and false insurance claims that are going to trial alongside and with the attempted murder and aggravated murder charges. There is also a completely separate case involving forgery, mortgage fraud, and other fraud that will go after the murder case if it goes to trial. If she's convicted, it would not surprise me if they are able to resolve that. What we are covering today is the breaking news, the motions that we got brutally rebuffed from getting to watch, and the motions that we have on the record that we didn't get to. We're going to cover it a little bit. On the docket this morning was the judge's approval for streaming the trial. So Court TV has been approved for pool, and the court approved live streaming. I didn't think this was going to happen. We are not going to see court staff, and he also put a note, any child witnesses. I do not anticipate that there will be any. I do not think that there will be any child witnesses. However, if we get to impact statements, they may have impact statements from the children. Generally, those would be written and read into the record. We don't know. I am not assuming that we are going to have any witnesses under the age of 18. I think that is a standard caveat to all the cases that the judge does, because if you don't say it, you never know. This is from the hearing on January 8th. We weren't invited to. You are going to see some notes on this docket in different color. I made those notes as I started going through this because I needed the reference point because there is so much. This is a full day of hearing with a lunch break, and I needed that information. Getting into the motion for the day. Counsel for the state, Mr. Bloodworth, requests that the court address the motion to determine the admissibility of docket 913. What is docket 913, Emily? Docket 913 deals with docket 214, the walk the dog letter. Counsel for the defendant, Ms. Lewis, addresses the court regarding the motion. The court, for the reasons stated on the record, grants in part the state's motion to determine the admissibility of docket 913. Let's go take a look together at docket 913. We have not looked at this together yet, but we're going to look at what the prosecution was asking for in docket 913 because that was filed publicly and we have it. This is docket number 913 that we're looking at now, relating to docket number 214. This is the state's motion to determine admissibility of the walk the dog letter. Argument. The walk the dog letter is authentic. The walk the dog letter was written by the defendant. The defendant has admitted that she wrote the letter. She called it not a letter, but she admitted it. Sergeant Thomas located it inside the defendant's cell inside her LSAT study book. The walk the dog letter is non-hearsay. It's the statement of a party opponent. The walk the dog letter is relevant. And then they define relevance. Specifically, the prosecutor says the first 3 pages of the walk the dog letter are relevant because the defendant uses them to solicit false testimony, which reveals her consciousness of guilt. Prior to her arrest, the defendant consistently maintained to law enforcement, the Office of the Utah Medical Examiner, and a life insurance company that Eric Richins did not use illicit drugs other than the occasional THC gummy. As set forth in the opposition, at docket 794, the first 3 pages of the walk the dog letter instructs the defendant's brother, Ronald, how to testify in support of her newfound and otherwise entirely unsupported theory that Eric Richins obtained fentanyl from Mexico. Why solicit false testimony to support a fabricated defense unless you know you are guilty? So the court granted this in part. Do we know what part the court granted it in? No, because it doesn't say. It just says, for the reasons stated on the record, the court grants in part the state's motion to determine admissibility of 913. If I were to speculate as to what the court might have done in this circumstance regarding the walk the dog letter, it's that there needs to be proper foundation laid. The court can't just say, oh, it's admissible. You have to lay the proper foundation. They have to prove first, before it can come in, that it was written by Kouri Richins, and how we know it's written by Kouri Richins, etc. The defense, of course, was fighting to keep this out. The defense was arguing not just hearsay, but that it wasn't probative. The defense had also at some point argued attorney-client privilege, among other things. The defense had also argued years ago in this case at this point that the search on the defendant's cell was improper and that they couldn't prove that the letter was shown to anyone so that the letter couldn't be admitted. It doesn't matter if the letter was shown to anyone. It matters that she wrote it. It doesn't matter if she was able to complete telling her brother the walk the dog story through her mother. It matters that she tried to. It's also going to matter if the defense tries to bring in the mother or the brother to testify. It's going to matter a lot. So I think the walk the dog letter will come in after foundation is laid. And I think we'll hear about it some in opening. They move on then to docket 917. Counsel for Bloodworth requests that the court address the motion to determine the admissibility of docket 917. Docket 917 is the orange notebook. The orange notebook came up during motions to suppress, and the court had not suppressed the orange notebook. There were some other foundational issues with regard to the orange notebook. Counsel for the defendant, Ms. Nestor, addressed to the court regarding the motion. Ms. Nestor further addresses the court regarding a continuous objection. So Ms. Nestor is like, we object to the orange notebook and we keep objecting. Bloodworth argues the court addresses the parties regarding laying foundation at trial. Counsel for the state, Bloodworth addresses the court. Nestor addresses the court. Bloodworth requests that the court address the motion to pre-admit notes. And then they move on from there where the parties go back and forth. They talk about laying foundation. They talk about witnesses. They talk about making a showing. The court rules at trial, the state needs to make a showing. So I think that what the court is saying on the orange notebook is that you must lay the proper foundation at trial. I'm not going to tell you the foundation's been laid, but you need to show that the notebook that was taken out of the house belongs to Kouri Richins, was written by Kouri Richins, and when it was written by Kouri Richins. You need to be able to show those things. Emily, what's in the orange notebook? Well, law nerds, I'm so glad you asked. Docket 917. State's motion to determine the admissibility of the orange notebook. This is the one I refer to as like, Dear Diary. The state respectfully moves the court to determine the admissibility for trial of the first 5 pages of the orange notebook, docket 914, non-public, Bates 1075 to 1079. So we do not have these items. These were filed under seal. We don't know what's in them, but we're going to find out a little bit more about what they are. Statement of relevant facts. Detectives seized an orange notebook from the defendant's place of residence on the day that the state charged her for aggravated murder. The first 5 pages of the orange notebook contain defendant's handwritten journal detailing the events of March 3rd and 4th, the night of Eric Richins' death. They say the first 5 pages of the orange notebook are relevant because they provide the defendant's first-hand account of the night of Eric Richins' death. They contain certain details regarding timeline, the defendant's movements, what Eric Richins consumed, among other relevant details. These details, especially when compared with other evidence in the case, tend to make it more probable that the defendant poisoned Eric Richins with fentanyl. Nothing about the first 5 pages is unfairly prejudicial. They do not appeal to the jury's sympathies, arouse a sense of horror, or provoke its instinct to punish. The first 5 pages do not describe or delight in Eric Richins' death. Nobody forced or coerced the defendant to write the orange notebook. The defendant holds a master's degree. She journaled, risking the likelihood that detectives would find it and recognize it for what it is. Any prejudice is entirely fair and well earned. The defense, I imagine, is going to argue, well, we don't know when this was written. And the prosecution is going to say, doesn't matter when it was written. She's detailing what happened that night, so it doesn't matter how close in time to that night she wrote it. She wrote it sometime between the crime happening and her being arrested. So she wrote it within a year of when it happened, unless she dated the page. And she might have dated the page. Who knows? So this is the arguments regarding defendant's interview statements and email. Detectives interviewed the defendant at her residence April 14th, 2023. That interview was contemporaneously recorded and transcribed. The state proposes to admit these things. The interview contains 6 distinct statements. 1, Eric Richins' health history. She talked about the night of Eric Richins' death, phone deletions, text messages, photos, and things like that. Phone deletions, the Eric Richins living trust, life insurance, power of attorney. They say the defendant's statements from the interview the state is requesting to pre-admit are in Docket 1159, which is sealed. The state is not seeking to admit the portions of the interview redacted in yellow. They go on to say that the defendant's statements are complete. So the defense, I wonder if they are arguing partly rule of completeness, like you need to put in the whole interview. I'm sure they're going to say, fine, put in the whole interview then. However, the prosecution might have a circumstance where they're like, no, some of these things need to be redacted. And if the defendant wants to admit those, they need to come in and testify to it. Remember, when you are looking at the statement of a party opponent, the prosecution can pick what statements of the defendant to put in. The defense can't do the same. So if there was an interview that the defendant gave and the defendant's interview was all like what they think a defense might be at trial, the prosecution could choose not to admit that interview at all, period. They could choose not to use it. And if the defendant wants to use it, the defendant can sit on the stand under oath, be cross-examined, and say whatever they want to say. But what the defense can't do is say, I want this interview in, and then admit that interview and put it in. So if the prosecution chooses to use an interview and wants to use only parts of it, then the defense can argue not, well, we want all these statements in. What the defense can argue is, well, we need it to be more complete. We talked about this a lot in the Karen Reed case with Karen Reed's interviews to the media. If the prosecution can cherry pick statements, can't the defense put in the other statements? No. But they can argue that the statement is out of context and you need more to complete it. So I wouldn't be surprised if we saw the defense arguing completeness. The defendant cannot put in their own statement. So the prosecution can put in parts of interviews. The defense can't put in alternate parts of interviews. They can only ask for completeness. They can't just clip things out of context to present a misleading impression, but they don't have to put it all in. If the defendant gives the rundown of what happened that night and then gets into all of their excuses, they can cut that part out and say, if you want to testify to all these excuses, come in and testify then. They go on to say that the defendant's statements from the redacted interview and email that the state seeks to admit do not create a misleading impression. The remainder of the interview and the email is not necessary in fairness to clarify, qualify, explain, or contextualize the statements. Let's see what the court says regarding that, because we are dealing with Docket 1163, and the court is allowing surreply here. So the defense will have another opportunity to argue, and the defense might want to put in some more law and be arguing here, look, Your Honor, if you're going to let in this whole interview, you should let in the whole interview. The court will defer ruling regarding the yellow portions, but all others are admissible. So the court is not ruling about the redactions yet. This is the state's motion to determine the admissibility of defendant's jail calls and text messages. Yes, the defendant has a device where they are able to text. The defendant's jail calls and text messages contain certain details regarding her procurement of quote unquote pain pills from Carmen Lauber, her knowledge about quote unquote what happened after she went to bed on March 3rd, the toxicology of Eric Richins' body, Valentine's Day 2022, Eric Richins' attitude about suicide, the witness Hayden Jeffs, her consultation with a divorce attorney in 2021. What did you say? Her consultation with a divorce attorney? She was on her jail calls talking about her consultation with a divorce attorney in 2021? Oh, that's new information. We know that he did. We didn't know that she did. Her consultation with a divorce attorney? She was on her jail calls talking about her consultation with a divorce attorney in 2021? Oh, that's new information. We know that he did. We didn't know that she did. That's interesting information. Here's why. The argument from the prosecution is that, or in part, that the defendant knew that if she divorced Eric Richins under their prenuptial agreement, she wouldn't get part of his business, the house, or most other things. Now, I think there is room to argue if you're the defense. Kouri Richins was in love. She knew there was going to be a prenup about his business, and she was like, blah, 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 business, business, business. I'll sign it. I'm ready to get married. And a huge part of the prosecution's argument here is that Kouri Richins was aware that if Eric Richins died while they were married, she gets the house, she gets half the business, she gets all the money, she gets the life insurance and the rest of it. But if they divorce, she doesn't get his half of his successful business. She doesn't get the house that is in only his name. There are things that she does not get. But if she's talking to a divorce attorney, the thing a divorce attorney would say is there a prenuptial agreement? Let's look at it and talk about it together. It makes it easier for the jury to understand that this was on her mind leading into February 2022. Characterized as the ultimate quote-unquote family man in his obituary, Eric was a member of the Church of Jesus Christ of Latter-day Saints. We knew that. We saw it in the Walk the Dog letter when Kouri's like, he hasn't even gone to church. He had gone on a 2-year mission to Mexico City. That makes more sense. This fills in the gaps a little bit that his mission was to Mexico. That in the Walk the Dog letter, they wanted to build a connection to Mexico. We need some kind of connection. Well, that makes sense. In trying to summarize what happened in the sealed hearing of the Kouri Richins case on the motions in limine, some of the motions in limine that were addressed in court were filed publicly. So we had a chance to look at what the prosecution is asking for. But a lot of them weren't filed publicly. And we have very vague references of what the court was considering and denying or allowing in court. A lot of that was in the defense motions in limine. In the prosecution's motions in limine, we saw things like the Walk the Dog letter, and the prosecution asked for the first 3 pages of that letter. It seems that the court has said, once the proper foundation, etc., is met, that is going to be admitted. It seems, based on the very vague minute order rulings that we have, that the court will be allowing the Walk the Dog letter in, that we will be seeing numerous jail calls from Kouri Richins. We learned some new information about what's in those jail calls, including the fact that on recorded jail call, Kouri Richins is talking about a meeting she had with a defense attorney in 2021. We know that Eric Richins changed his will and the trust and how his estate was to be handled in 2020, November of 2020. So we have Eric Richins changing things in November of 2020. We have Kouri Richins having a meeting at some time in 2021 with a divorce attorney, which is going to allow the state to make some more arguments about what Kouri Richins knew about what was in the prenuptial agreement. And then we have the February 14th, 2022 attempted murder charge, Kouri attempting to poison Eric Richins, as the prosecution alleges. And then we have the homicide that's charged in this case for Eric Richins. So we are looking at from late 2020 to very early 2022, quite a lot happening. I'm very interested to see what else is in those jail calls. But the jury, it seems, is going to hear that Walk the Dog letter where Kouri is lining out the connection that her attorney Sky wanted to make between Eric Richins procuring drugs and fentanyl from Mexico. We also took a quick side quest to look at an article from people.com because there were motions in limine regarding the children's book that Kouri Richins apparently had ghostwritten, and the cover of the children's book that shows Eric Richins with a halo and angel wings on it coming out of the clouds. And in that article, People states, and I imagine that they would have spoken to people that knew Kouri and Eric, but states that Eric Richins went on his mission through the Mormon Church to Mexico City. I didn't know that there was more of a connection between Eric Richins and Mexico, aside from what we had seen in the walk the dog letter. I don't know if the jury will know that. They might not, but it does close some loops for us understanding why that might have been such a, hey, we need to connect these things to Mexico, because Eric has a connection to having lived in Mexico City for 2 years. And maybe that's why Kouri was so focused on it in the walk the dog letter / novel. Also, I think if Kouri Richins comes up and tries to testify that that's all fictional, it's a novel, will we see the prosecution be like, girl, you didn't even write the children's book? I don't know. Maybe we will, maybe we won't. We also learned that there are more text messages from in custody that the prosecution wants to bring in, that the prosecution is asking to redact certain portions of conversations and then admit quite a lot of defendants' recorded jail calls and text messages, of course, in addition to all the other digital evidence that we have seen. So in looking at the court's rulings, we know that the walk the dog letter, once it's, shown that Kouri Richins, I think, has authored it, is going to come in. And then the court also made ruling about an orange notebook. And we heard reference to the orange notebook during the motions to suppress, where the defense was arguing that that was improperly seized. It seemed at that time that the prosecution was going to be arguing inevitable discovery. And then we are at the point now where they're arguing what part of that orange notebook comes in. The prosecution said that it was journaling about the March 3rd, March 4th time period of the passing of Eric Richins, and that the defendant lays out in her journal what happened from her perspective in that time frame, in the first pages of that orange journal. So Kouri Richins, according to the prosecution, was journaling about the death of Eric Richins, and they have sought to admit that. And it seems that the court's ruling is that that is going to come in, again, if the proper foundation is laid for it, that journal is, in fact, in Kouri Richins' handwriting, that she is the one that wrote it, etc. So the prosecution is going to have a lot of Kouri Richins' own statements, writings, recorded calls, and more coming in. When this goes to trial on February 23rd, we also saw a docketed item today that Court TV has been granted pool camera access, and the court is allowing live streaming. So, will we be streaming gavel to gavel from Utah again? Yes, we will. There are going to be a few hearings before jury selection gets underway on February 11th. I don't know if those are all going to be sealed or not, but at this point, it seems that the court would rather lock everything down until the jury is seated. So I imagine we might not hear any more in court or see any more coverage in court other than the filings that are going to be busy between the end of January and the beginning of February when jury selection begins. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the LawNerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.